The court system is rather, well, it's simple to me, but it's rather simple. It starts with the municipal court level. Each town has a municipal court judge, and they hear traffic matters, minor criminal cases, harassment, trespassing, things of that nature. That's the first level of courts in New Jersey. The appointed process for that is the governing body of each town appoints a municipal court judge for a period of 3 years. They wear a robe, they appear in each municipality and hear cases based upon complaints that are filed either by private citizens, but mostly by police, speeding, traffic cases, things of that nature, even DWI, drunk driving cases. If anybody is dissatisfied with the decision of the judge at the municipal court level, they appeal to the basic level that we have in the court system called the Superior Court, the trial court. There are probably about 425 Superior Court judges. I'll explain in a minute how they get appointed, but each county has a number of Superior Court judges based upon population. A county like Essex County, Hudson County have more than, say, Ocean County because it's based on population. Even Ocean County has less than Monmouth County. But in Ocean County, we probably usually have about 20, 25 Superior Court judges. They're divided into an assignment judge, who is a chief judge for the county, for what they call a vicinage. Each county is called a vicinage. The assignment judge, and then there's the family court, criminal court, civil court, and then equity court. Those are divided into assignments based upon what the assignment judge recommends to the Supreme Court in terms of how the judges should be allocated among the county. To become a Superior Court judge, you have to be a lawyer for at least 10 years. And of course, the process for the educational process is, of course, obviously high school, a 4-year college degree, and then a 3-year law degree. I went to the University of Miami School of Law. I graduated from Monmouth University, and then I went to University of Miami Law School. Unfortunately, I got drafted right out of law school during the Vietnam War. I didn't go to Vietnam, I went to Germany instead, but I spent 2 years in the Army, having been drafted. And then when I got out of the Army, I finished up my last 2.5 years of law school. I graduated and became a lawyer. I was with a firm called the Lamel Law Firm in Toms River, and I spent about 11 years as a trial lawyer, basically. Handled all sorts of cases, primarily liability cases in court, tried jury trials and so on. Loved trying jury trials. And the Superior Court level, as I said before, in order to jump from a lawyer to a Superior Court judge, you have to be a lawyer for at least 10 years, and you have to be recommended, usually by the state senator in your county, to the governor's office. The governor then takes under advisement, does what they call a 4-way state police check to make sure you have no criminal background or you're a good moral character and things of that nature. And then if the governor is satisfied, the governor would appoint you as a Superior Court judge or nominate you as a Superior Court judge. Then you go before the Senate Judiciary Committee, just like you do nationwide, Senate Judiciary Committee. And if the Senate Judiciary Committee passes you, you go to the full Senate, and the full Senate confirms then the nomination of the court if you're so lucky, which I was lucky to do. I went on the bench in 1986 as a Superior Court judge and went into the family division. I had never done a family court case, but they had a vacancy in the family court in Ocean County, so I spent 12 years in the family court. The next level above the Superior Court level, as I said, there's about 425 Superior Court judges strewn throughout the 21 counties in New Jersey. The next level up from that is the appellate division of the Superior Court. The Chief Justice of the Supreme Court appoints from the 425 judges, 32 judges to sit in the appellate division. The appellate division is divided into 8 4-judge parts. Each part hears cases appealed from the criminal, civil, family, or equity of the Superior Court level at the county up to the appellate division of the Superior Court. I sat in the appellate division for 10 years, became a presiding judge. They go by seniority. Of the 4 judges in each part, whatever judge has been on the court the longest becomes the presiding judge for each of the parts. So there's 8 presiding judges, and then each 3 other judges in each of the 8 parts. We would handle appeals from criminal cases, family court cases, civil court cases, and equity cases. We also heard administrative appeals. Give you an example. The Division of Environmental Protection, if you made an application for a permit to do whatever you want to do, put a dock in, whatever, or build in an area that was had to be get approval from the Department of Environmental Protection because it's an environmental sensitive area, and you got denied that permit, you would appeal to what they call the administrative law judge. There's administrative law judge level, which is below the Superior Court, but it handles any administrative appeal. If the Department of Environmental Protection denied your right to build a dock, let's say, for example, or to build a structure within an environmentally sensitive area, you could appeal to the administrative law judge, and the judge would hear it, and if whatever the judge decided, that could also be appealed to the appellate division where I was. So we heard administrative appeals as well. Above us, the 32 of us, was the 7-member Supreme Court. Supreme Court, of course, goes through the same process. Sometimes it's a lawyer who's appointed to the Supreme Court by the governor, and sometimes it's an appellate judge to move up until a vacancy if somebody retires or dies or whatever it may be, resigns. The vacancy is created. Again, the same process. The Supreme Court justices are appointed by the governor. They're approved by the Judiciary Committee and the full Senate, and then they become a Superior Court or a Supreme Court justice. All judges in the Superior Court level, whether it be at the trial level, appellate level, or Supreme Court level, have to retire mandatorily at age 70. It's a mandatory retirement at age 70. You can be brought back, as I was. I'm now 79, but I still spent time in the court system. Brought back, they recall or bring back a Superior Court judge to help with the calendar flow. If the calendars get overcrowded, they would appoint, and I did that for a number of years, both during all the Superstorm Sandy cases, where we had litigation over those. I presided over all those in Ocean County on a recall. And I also sat in the family court, and I also sat in the appellate division to help out with the caseload there over a period of time. I'm not doing that anymore. I was also appointed by the Supreme Court on 2 what they call special master cases, where the Supreme Court gets a case, they agree to take a case, but there's not an adequate record, meaning testimony and exhibits are not adequate for them to make a decision. They appointed me on 2 cases to create a record. I took testimony, took evidence, and then did a report to the Supreme Court so that I had an adequate record to make a decision on the case. All appeals from the municipal court to the trial court, Superior Court trial level, are of right. You can do that as long as you file a notice of appeal within 45 days. You can appeal as of right to that. And the same with the trial level of the Superior Court. If you had a family court case you were unsatisfied with, or a criminal case you were unsatisfied with the jury's verdict, you could appeal to the Superior Court appellate division, where I was, as long as you file a notice of appeal within 45 days from the decision. The Supreme Court, however, there's no automatic appeal right, except in murder cases, that type of thing. Other than that, there's no automatic right. The Supreme Court can agree or not agree to take a case. You can petition the court, let's say the appellate division, where I was, if we decided the case, and the loser wasn't happy, or the winner wasn't happy by the extent of what we decided, they could petition the Supreme Court to take the case. The Supreme Court, in its discretion, could take or not take the case. In the appellate division, we handled each judge wrote probably about 120 written opinions. We do a written opinion in every case in the appellate division. So when I was in the appellate division, we sat from September, every week from September until June. In the summertime, we just heard emergent matters and had what we call a summer sitting on emergent matters. But from September to June, every week we would hear cases, and then we would each write 4 opinions a week, written opinions on the case. Some were as little as 5, 6, 7 pages. Some were as long as 70, 80 pages, depending on the complexity of the case. Not every case is published in the books. Unpublished decisions were most likely. In other words, out of the 120 cases that I wrote every year, maybe I would publish 5 or 6 cases, 5 or 6, 7 cases. If they were new law, if they expanded the body of law or of interest to public interest, I wrote, I think, 52 published opinions that are in the books over the years that I was in the appellate court. But it was a wonderful experience and wonderful honor to be able to serve in the court. I handled appeals on murder cases. Our part would handle those, render a decision as to whether the verdict should be sustained or not, or affirmed or denied, or sometime remanded for further findings. There were civil cases, family court cases, everything you can think of, administrative law cases that we would decide. It's an intensive court. You're isolated. Each Supreme Court justice has 3 law clerks who are law students that graduated from law school and they're waiting to practice law. They will serve a year with a Supreme Court justice. Each Supreme Court justice has 3 law clerks. Each appellate judge, the first 2 senior judges, which I was, we had 2 law clerks each, and they served for, they're law school graduates who were waiting to practice law. They served as the law clerks for us and did research and so on. At the trial level, the 400 and some odd Supreme Court judges at the trial level have 1 law clerk each. And again, from September to September they serve, and they're law school graduates. There are some opportunities in some of the trial courts for what they call law interns. A person who's going to law school first year or getting ready to go to law school, in between they can serve as an intern. Some counties have paid interns, some do not. Some it's a volunteer thing, but it gives you an opportunity to have a brush with the law, so to speak, in terms of helping out with cases and sitting in and doing some research, things of that nature. But they're generally law students. And that's pretty much how the court system is set up. Well, I love the family court. I never did a family court case when I was a lawyer, but they had a vacancy in the family court in Ocean County. So Judge Serpentelli, who was the assignment judge at the time, appointed me to the family court, and I eventually became the presiding judge. Each presiding judge of family, presiding judge of criminal, presiding judge of civil, presiding judge of equity. I stayed in the family court. I had the opportunity to move over to civil or to criminal or equity if I wanted to, after spending some time in the family court. But I thought it was the only place where you could help people, because family court cases are the toughest. You're dealing with emotions. You're dealing with people who formed a relationship, whether it be a custody case or whatever the issue may be, equitable distribution of property, support, we call alimony, which is spousal support or child support. What you decide lives with those litigants for a good part of the rest of their life. In a criminal case, some criminals think that committing criminal acts is a way of doing business. I mean, unfortunately. But nevertheless, it's a beginning and an end to the case. Even the sentence is over. a family court case is never over. There's always issues about custody and what they call parenting time or visitation or support, and there's a lot of emotion in those cases. So you have an opportunity to help people chart out the rest of their lives, and you have to try to make them understand you're there to help them as a judge. That's the primary obligation, I think, of a judge, is to help people. You're there, you're a public servant. You have an obligation to do things fairly. You have an obligation to hear everything that everybody has to say. So my practice was always to let people tell me everything that they wanted to tell me, so I knew everything about what their position was to make an adequate decision. And then I tried to formulate a decision that would help both parties as well as the children. The children, of course, are potentially the victims of a divorce because they were brought into this world by their parents, and then all of a sudden they don't have two parents anymore that are together, they're apart. So you have to make sure that the children, to the extent it's appropriate, have a good relationship with both parents. That type of thing. There's also, in the family court, you hear other types of cases too, adoption cases. There's nothing more fulfilling than handling an adoption case where a child becomes adopted by parents, by new parents, either because their parents have died or because they've been the subject of abuse, and the parental rights of their parents have been terminated. That's also the kind of case you handle too, a child abuse and neglect case, termination of parental rights case. You try to help people. You try to interview the children, try to make them understand you're there to help them, that everything's going to be okay, and you try to formulate something that allows the parents and the children to move forward in a way that's going to be productive for them and beneficial for their development as human beings. I always try to get parents to, what drives a family court case are emotions, anger, desperation. They have nowhere to turn, they believe. Obviously, if the family unit had income of $50,000 and now you're making two family units, you don't only still have that $50,000, there's less money to go around. And so it's a hardship for people. They try to help people as much as you can. So I like the family, that's why I stayed there. Civil cases are fine, but generally, people have an accident case, they get injured, and they're entitled to be compensated to the extent of their injury. If it was the fault of someone else, called liability, once it's over, it's over. There may be some residual injury, there may be some hard feelings, but it's not the same as family court, which has really, it's the essence of who people are when they formulate a relationship. They give up all their essence as a human being, they put down all their guards, and then they feel betrayed. It's a hard thing for people. So I love the family court cases the most. Everything else you handle, like I said, I was doing the Superstorm Sandy cases where people had their houses either partially or fully destroyed, and they filed cases against insurance companies who hadn't maybe paid them, in their view, the amount that they were entitled to, and again, their lives were derailed, so to speak. So you tried to help them through those, and we tried some of those and settled most of them. In the court system, we have also a process of mediation. Mediation is where you try to get people to agree without going through a trial. You try to get them to settle the case, if you can. When I retired from the court system at the end of 2006 as a Superior Court judge, and went on retirement status before I was recalled, I formed with Judge Klein and Judge Serpentella, we formed Benchmark Resolution Services, LLC, which was a mediation and case management separate entity. And I got to mediate the cases, both in family and civil. You don't mediate criminal cases generally. But in any event, and that was fulfilling as well. As a retired judge, you would go out to the attorney's offices and you tried to, and I was fairly successful at that and had some good results, and some people became friends. I still have some of the litigants contact me, send me Christmas cards and things of that nature, and it's fulfilling. It's a good career, but again, you have to view it, and I don't know that everybody does view it this way, but they view it as your duty is to help people. And that, I think, is what we as a system look for in judges, that have a desire to help people, not hurt them. And that's kind of the way the system is set up. There are committees, Supreme Court committees. I sat on the Supreme Court Family Practice Committee. I chaired a couple of other committees on attorney malpractice insurance. It was an issue there, and all sorts of other cases. And I enjoyed the committee work as well. You meet with lawyers. The committee is usually made up of sitting or retired Superior Court judges and lawyers, and you try to formulate a position that the Supreme Court has asked you to take a look at to see what's best. When the child support guidelines came into effect, I sat on that committee and did a lot of training on child support guidelines, and did a lot of courses too. And as I told you, wrote a book on family law with regard to custody and child abuse and neglect, child protection, and child support. And I enjoyed doing that. You would teach for what they call the Institute for Continuing Legal Education in New Jersey, which is based up in New Brunswick, which is an institute made up of the Bar Association, but it's an independent entity, and they give judicial education. All lawyers and all judges, even retired judges, up to, as I've been a lawyer, well, I was sworn in as a lawyer in 1973, so I've been on 51 plus years as a lawyer / judge, but you're always a lawyer underneath, quite frankly, and whether you're a judge or a lawyer, you still are a lawyer. When you don't have to have your continuing education if you're on 50 years, so I'm not mandated, but I still do it anyway. And every lawyer is required, every judge is required, who doesn't have 50 years of service, to have so many credits of continuing legal education, which was put in by the Supreme Court probably about 10 years ago as a requirement, 10, 15 years ago. And I think it's good because it gives continuing education in different areas. We also have an annual judicial conference every year, and then each of the criminal, civil, and family have a conference every year to go over whatever issues that are current. So you keep everybody up to date with things, and I participated in those as a presenter on many occasions as well. Sure. The classic case is domestic violence, which is a type of case that's handled in a family court all the time, where people who have lived together, whether it be same sex or opposite sex, or married or not married, doesn't matter. If they live together for a period of time or cohabit for a period of time, or have a interpersonal relationship with or without children, if one party abuses the other party, whether it be physically or harassment, they can file a order of protection, a domestic violence restraining order against the other party. Almost all of those are he said, she said, or he said, she said, he said cases. And you have to make a determination based upon the evidence who you believe. You watch how they react to things, and when you make your findings, you have to make a finding. I find that the defendant has committed domestic violence. I've watched him or her speak. Some things are inconsistent. I don't think that being entirely truthful, and therefore I'm satisfied to grant a restraining order, or I can say that I don't believe the plaintiff's allegations are correct. For the following reason, I have to explain why. I would have to explain why you make your decision. Give an explanation, your findings, whether you have credibility usually, who you believe more. And yet, those are classic he said, she said type cases. In the family court, it's usually a lot more gray area where you're not completely satisfied, and you try to make your decisions based upon what you think is the right thing to do. That's the bottom line. You want to do the right thing. If there's children involved, you always want to do the right thing for the children. Whatever you think is going to be beneficial for the children is the main thing. But you don't want to cut a parent out either, because it's important that the children have a relationship, even with a parent who is not necessarily abusive, but doesn't have the kind of warm, connective relationship with the child as the other party does. You want to make sure that you try to nurture that through counseling. You can mandate counseling. You want to make sure that you don't cut a parent off. The parent has some type of. Children are smart. They get to know as they start to grow up. They get to know things about their parents that they deal with and compensate with. But they need to have a relationship. You can't cut a parent off generally unless there's physical abuse, that type of thing. If a child is being, and there have been cases like that where a parent, because of anger management issues, has abused a child. There's no tolerance for that type of thing in our system, and therefore you need to protect the child. If you have to protect the child, you may cut off or limit contact. You order supervised visitation, things like that. Whatever's best for the child in situations like that, but whatever you think is the right thing to do, even if there weren't children involved for the parties, you try to let people move on with their lives in a way that they don't have to interact with each other, quite frankly, sometimes.
Were children able to give testimony as to like who they want to be
sure.
with? Yeah.
Sure. Oh, sure. You're mandated, and if you don't do it, you have to say why. You're mandated to interview children, usually age 6 or 7 and older. You conduct what they call an in-camera, meaning in your chambers, interview with the child, like we're doing here, which is not an open court. You would interview the child, and you just talk to the child. Tell me about your mom. Tell me about your dad. What do you like to do? Who's your best friends? What do you like to do? Who takes you to school? Either your parent go to school? Do you have any activities you do? Who participates? You try to get an idea about what parent is really parenting the child, and then if the child, you don't come right out and say, who do you want to live with? You never say that to a child. You kind of glean all that based on what the child is saying. Hey, tell me about, how do you feel about mom, and what's your relationship with dad? Explain it to me if you could. That's the way you deal with a child. You don't come right out and ask them the bottom line questions. That's your job to determine what the bottom line should be. And then then after you're done with interviewing the child, you go out on the record and say, I've interviewed Johnny or Sally, and here's my impressions. And you explain your impressions about why you're going to do what you're going to do. And it's only and the child interview is one factor in many, many factors about how you're going to divide the parent's time with the child. Or there's what they call joint legal custody and joint physical custody. Legal custody is different from physical custody. Legal custody is the right to make decisions on where the child goes to school, what doctors the child goes to, things that involve that type of thing. Physical custody is who's the child go with and when, Mm-hmm. So it's legal and physical. Usually you try to give both parents joint legal custody, but the parent that you give primary residential custody to usually has the right to make the ultimate decisions on things. But you require them to talk to each other about it. And if they have a fight about it, and they often do, they come back to court, and then you have to decide, the judge. So you get to know families. I remember a couple of families that when I started in '86, by the time I left the family court to go to the appellate court, once in a while I was bringing them back for a tune-up. Even the hypothetical Smith family, that type of thing. You'd bring them back, and they got to know you got to know them, and if they had a problem, you try to be an intermediary to help them get through it, but it's ultimately you have to make the decision. That's what they come to you for. I always say, you came to me, I didn't come to you. So, I'm not trying to hurt you, I'm trying to help you, but remember, you came to me, I didn't come to you. So I'm trying to help you, but ultimately you got to listen to what I'm trying to do for you. And if you work with me, it's going to be okay. I'm not trying to hurt you, I'm trying to help you, but but you, remember, you came to me. I didn't come to you. So I'm trying to help you, but ultimately you got to listen to what I'm trying to do for you. And if you work with me, it's going to be okay. That's how I would approach it. Just talk to them like you would talk, like we're talking here.
Yeah, exactly.
It's important to do that. Not everybody does that, quite frankly. I've taught many cases, many courses on that type of thing. Judicial demeanor. I think it's important that a judge have good demeanor. I used to call my well, let me back up a little bit. When I was also the chair of the Judiciary Education Committee when I was in the appellate court. All judicial education things were decided by myself and our committee, but I was the chair. So I said, you know, we need a course for when new judges come on called the Comprehensive Judicial Orientation Program, particularly in family court, but we did it for all the divisions. And so I got the Chief Justice to agree that no judge would hear a case until they took our course. Family court was my course. And you try to teach judicial demeanor to people and make them understand things that I'm telling you now about how you're there to help people and whatever. And we would go over cases, we would go over how you comport yourself, how you act as a judge. I used to call it the anti-Judge Judy case, of course, because, you know, Judge Judy's Hollywood. She was I met her years ago. There's a family court judges association in New Jersey. There's one in every state. And we used to go to national conferences, and I met her. She's about 4'10", you know, and she's, you know, and she was fine. But once she became Hollywood, so to speak, they yell at people, you know, and these other judges that's not reality. That's not what, if you yell at people like they yell at people on TV, you'd be up on judicial ethics complaints, because you can't treat people like that. You really can't. It's not appropriate to do that in the real world. In Hollywood, anything's appropriate. You know, whatever sells, whatever
makes money,
whatever
yeah.
entertains people, you know, but real life is not entertainment. This is not, you know, these cases are not entertainment for either the judges or for the people that come before. This is real life stuff. This is important stuff in their life. They come to you to try to help them. That was always my view. And I try to help them. And that's the whole thing. But so the anti-Judge Judy course I gave many times. I would start off like that. Everybody would laugh, like you're laughing now. And we had a good time. We had a good time. And the judges were, and I used to get calls from judges. Hey, Bob, I got this case. What do you think about this? And we would talk. It was fulfilling. And we would meet in our Family Court Judges Association a few times a year at different locations around the state. And it was always good to interact with other judges. It's a good judiciary. And we had you know, the other thing is we have a judicial code of ethics as well. You can't do anything. You can't do anything political once you become a judge. You can't, when I wrote a book, you can't take royalties on the book. As opposed to the U.S. Supreme Court, where all those U.S. Supreme Court justices, they write books and get $700,000, $800,000, $1 million in royalties. We can't do that. The U.S. Supreme Court finally has a code of ethics, but it's only enforceable by each justice enforcing it themselves. There's no overall. We have a advisory committee on judicial conduct in our state. So if any judge deviates from that, they get brought up on a complaint. They can be disciplined or removed if it's serious enough. And we've had some removals over the years, and we've had discipline over the years. So we have a strict ethics code. We always have had in New Jersey. I think that's very good.
I do.
Because it keeps everybody on the straight and narrow, so to speak. It's not, and I don't think a lot of people really even know that or understand that. There was a recent issue in Point Pleasant Beach Municipal Court. Municipal Court judges are under the same code of ethics. The judge was posting on Facebook certain things, and he got disciplined as a result. And he admitted it, and to his credit, he admitted it. But it was taken care of. My point is that they look to make sure that you're as impartial as possibly can be. and that you have no conflict of interest whatsoever. For example, if you know somebody, you can't have them appear before you. It's inappropriate. It's a conflict of interest. Or if you have a financial interest in something, and that entity comes before you, you can't hear that case, rightfully so. There's a conflict of interest. Not so with the U.S. Supreme Court so much, from what I can see, which is disappointing to me, quite frankly. And I think should be taken care of, but there's a lot of things at the federal level that aren't taken care of that probably should be, quite frankly, even at the judiciary level.
Are you also talking like state Supreme Courts as well, or are you just talking federal?
I'm talking about the U.S. Supreme Court.
Gotcha.
The state Supreme Court is under the same constrictions as all judges or justices in New Jersey. We have a very, very strict ethics code, and it's very, very good in the public interest, quite frankly. It's in the public interest. It's the right thing to do. So all the judges that I've ever dealt with are adhere to all that, and you know, look, it's like anything else. Some lawyers are better than other lawyers. Some judges are better than other judges. That's okay. Doesn't matter. As long as you have the same approach, that you're there to help people, and you're sincere about it, and you do the right thing, you're fine. So it's a great career, and you know, I encourage young people to go to law school. Law school's expensive now. I get that, but I encourage, and you, for example, or others that want to intern, you know, I can connect you up with the assignment judge in Ocean County and see if they have an intern program, and if they do, you know, it gives you an opportunity to see if this is what you want for a career, for example, for yourself or other people as well who are interested in the law. It's a great career. The law is a great career, whether it be a lawyer or as a judge. There's nothing like it, you know. And I'm retired now, fully. I stopped. The last assignment I had was on the statewide DWI cases. Where we had unfortunately, they had a person that administers the Alka-Test, which is like a breathalyzer test, had falsified the certification of the machines, and therefore a lot of DWI cases that were based upon readings, breathalyzer readings or Alka-Test readings, breath sample readings, based on machines that had been improperly calculated, were subject to being reversed or changed or whatever. So I had to handle all those cases and set up a procedure for the Supreme Court how to do it. As a special master, I probably spent about 6 months taking testimony and evidence, technical evidence, and and then the Supreme Court adopted my report in a Supreme Court did in a written decision about less than a year ago, 6 or 7 months ago. But when I was done with my case in October of 2014, I'm gonna be 80 years old. That's enough. You need those young people to move on. I mean, you have to. There's a place to start. There's time to stop anything. But I still have an interest in it. But I don't actively judge anymore.
Right.
I get enough. I have to judge enough. 6 grandkids and my wife and everything else. We have enough. That's good enough. That's good enough for me right now.
Right. Well, thank you for your service, truly. And I think like everything that you've kind of ushered into our judicial system here in Jersey is, I've agreed with like absolutely everything that you said in terms of like judicial education and whatnot. However, I do want to touch upon the point that you brought up about like, again, as a judge, you're there to help people. So you've presided over criminal cases, I would assume, correct?
Not so much. I spent all my time only in criminal at the appellate level.
Right.
Not as a trial judge in a criminal case. I never handled a criminal case as a trial judge. As a lawyer, I did. And in the appellate court, when you're looking to see whether there was error in the conviction, let's say, I handled those, but I never actually handled a criminal case before a jury, so to speak, as a judge. As a lawyer, I did, but not as a judge.
Right. And so you, from your judicial perspective, how does somebody with like the kind of like community-focused, helping people first mentality go about sentencing? Like, how do you view sentencing? Is it to punish the perpetrator?
Sentencing is based upon, there's a statutory criteria for sentencing, where you take a number of factors that you consider, including danger to the public or whatever, the nature of the offense. Every case is different. A manslaughter conviction can have a range of sentencing, anywhere between a few years up to, depending on the extent of it, the nature of the offense. All these statutory criteria have to be analyzed by a judge. If a defendant is convicted of a crime, there's what they call a pre-sentence report that's done by the probation department. And they look into the background of this particular individual who's been convicted. And they analyze all these factors and they present them to the judge, and then the prosecutor and the defense counsel argue against those factors as to what the sentence range should be. There's always a range of sentencing, and the judge can give a more lenient sentence or a more strict sentence based upon the nature of the offense and analyzing that criteria. The key is, is this a person that's committed numerous offenses? Is he a danger to society, or she a danger to society? Was the nature of the offense so heinous as to require separation from the rest of the world in prison for a period of time or not? And the prison system itself has rehabilitative processes. There are, you can get, sometimes they have these halfway houses that they send people to re-educate them. They have programs in prisons. Many prisoners who don't have high school education, for example, can get a high school or even a college degree while in prison, and they rehabilitate themselves. So the idea is rehabilitation. My view is that not everybody can be rehabilitated, quite frankly. There are all sorts of other factors. Some people have mental disabilities or mental illness that prevent full rehabilitation. So you address those issues, the mental issues, that you try to properly medicate them, analyze them, or whatever. The prison system New Jersey is pretty good actually in doing that. They can get a probation after a period, or parole after a period of time. You can enter a sentence of, it's a life sentence, but with no eligibility for parole, or a life sentence with eligibility for parole at a certain point in time. What we call, or you can do what's called a 30 over 15 type sentence, where it's 30 years, but after 15 years they can be eligible for parole if the parole board is satisfied that they're ready to go out into society again without being a danger to themselves and properly rehabilitate themselves. So it's, you look at all the factors that you can possibly think of. Their family structure, what are you doing to the rest of their family by incarcerating them or not? Is this appropriate to do in light of the violation of the law? Can it be done through a probation system as opposed to, or a monetary fine as opposed to incarceration? There are many, many factors you consider. It's interesting. The statute lays out probably about 15 to 25 criteria that you're supposed to consider and make findings on.
It's and similarly, like you said, it does impact the family of, say, the culprit, but also the victim, right? So when because I watch a lot of judicial hearings just on my own time, and I hear a lot of victim impact statements of people advocating for.
That's important. Victims are important. It's important to hear from them at sentencing as to how the crime has been committed against them or their family members, how it has impacted them. And that's a factor you consider when you consider the length of sentence, for example, or the nature of the sentence that you give. It's important you try to balance things out the right way. You can't say that there's no two crimes that are identical, but if they were, one judge may seem a little bit different than another judge, but not so much different, 5 versus 7 years, that type of thing. I mean,
right,
the idea is that we have a system of government that's based upon the criminal justice system that's based upon fairness and equity and treating everybody fair, including the victims, clearly. So the victim impact statement is always important.
Now, I would like to go into more like abstract ideas, I guess.
Sure.
In terms of like how you view the law, are you more of an organic thinker, or are you more an originalist type of thinker?
I'm not sure what you mean.
Should I rephrase?
What's that?
Should I rephrase?
Yeah, go ahead.
In terms of like, because I know that when we see like Supreme Court justices, they usually have like a particular like judicial philosophy, like
Oh.
they're living constitutionalists or they're originalists. Like, are you a Stephen Breyer or are you a Justice Scalia? Like, kind of.
Yeah, I see what you're saying. I probably am in between.
Mm.
I think that
That's a good way to be.
you can't be too rigid in how you interpret the law. You have to interpret this, what they call the spirit of the law. What was the intent of the law itself? What were they trying to address? What were they trying to correct? You look to the spirit of it, and you try to fit your case into the spirit of the law, what's appropriate. I don't believe that everything is just black and white, so to speak. Justice Scalia, God rest his soul, who was from New Jersey, by the way, strict constructionist. Okay, but to me, nothing is 100% black or white. You have to look and do things, again, what you think is the right thing to do within the ambit of the law. You can't overly stretch the law, okay? But you have to know what the spirit of the law is. What was the intent of the law? What was it trying to address? And is your sentence going to be consistent with that? That's how I look at the law. I want to hear what people have to say. I don't believe that any two cases are the same.
Mm-hmm.
I think every case is different, and every case should be judged based upon fairness, based upon what the spirit of the law is, what the law was intended to accomplish, and are you accomplishing that by your sentence? And that's the way I look at it.
Well, let me consult my notes because I think I have a couple more. Those
In
are
the
just-
law, there's always notes. It's a good thing. The more discussion you have, and the more any issue is analyzed, usually the better the result is, quite frankly, which is a good thing. Trial court and appellate court is different, but in a trial court, you have a calendar every day, or you're trying a case that you've selected to try. But my philosophy was to get to the courthouse early. I used to get up around 6, have breakfast, 6:30, 6:45, I was on the road. I was sitting at my desk in the courthouse by 7:15. The court day starts at 9. But usually you might have meetings at 8:30 with your case manager to see what's going on, with your law clerk, your secretary. And then at 9 o'clock, I was always prompt. You put your robe on, you get out on the bench, and you call the list, if there's a list of cases, and you decide how you're going to handle each case, and whether it be conferences, that type of thing. Usually you take conferences first, and you go out, and if there's a trial, you have to go out and start the trial of the case, depending on what type of nature of the case is. I always tried to make sure that very important to me was a continuous trial time in a non-jury context, which is what family court is, non-jury. The judge handles everything. There's no jury in a family court. If it's a jury case, it's different. But my day was I would go out and try to do all my business, calling the list, conferences, case management, orders, getting cases ready for trial in the morning, and then I would always start the trials usually around 1:30, 12:30 to 1:30 with lunch, 1:30 till 4:30, sometimes later, I'd do the trial of the case. That way the lawyers knew that they could do their business at their law offices in the morning. But you make sure you do it Monday through Thursday. Friday was always motion day. You handle motions or applications to the court on certain things. And you at least give them 4 days a week of continuous trial time, because everybody's different. Some judges in certain areas, counties or whatever, would you do a trial, you do one trial day and I'll see you 2 weeks from now. That's not, to me, that I didn't like that. I thought it's not fresh in your mind, and you keep notes, of course, but the people don't like. Why would you make them come back so many times? So I said, look, we're going to try a conference in the morning. I said, look, I'm going to start this case tomorrow at 1:30, and I want to do Tuesday, Wednesday, Thursday, and then I'll see you next Monday, Tuesday, Wednesday, and we're going to get the case done. Continuous trial time. And there's a rule that says that generally you should have continuous trials. Now, everybody followed that rule 100%, quite frankly, and I understand, because sometimes the volume of cases, family court, I mean, give you an idea, there are somewhere in the neighborhood of 1 million family court cases statewide filed every year. 1 million. Yeah. Of which probably about 60,000 of them are divorce cases, which are very complex because you have issue of valuation of property, valuation of businesses, child support, alimony, very complex. Sometimes the evaluations have to be done, custody evaluations have to be done by psychologists. They can be very intensive, but you have domestic violence case, you got everything, like 1 million cases. It's a lot of cases, a lot of cases. So the volume of cases can slow you down, but you have to manage your time appropriately. And then by 4:30 or so, you close up shop and do a couple administrative things, and you're out of the courthouse by 5 and home to eat dinner and get ready for the next day. That's kind of what it was. And by the way, all we judges, motions days were generally on Friday. You might have 30, 40, 50 motions. These are applications for, you file for divorce, but there's no order. Divorce isn't going to take anywhere up to a year to finish it. But what's going to happen in between? What's going to be the temporary support? What's going to be, who's going to live where? All those issues have to be decided as to what happens in between. So they make motions to the court, pendenti liti motions, which are pending the litigation. What's going to happen, Judge? What support are you going to order? Those are called motions. What's going to be the custodial relationship pending that? Those are motions you have to get. You get stacks of paperwork with exhibits that you have to look at. So when I go home at 5 o'clock and after I eat dinner, I usually spend a couple hours reading, getting ready for motion day every day. So it's an intensive thing. There's a lot of out of court time that you spend in terms of analyzing, and that's true for civil. That's true for criminal as well. Civil has a whole bunch of motions every motion day, and criminal does too. So, and getting ready for reading sentence reports. You can't spend your time in chambers when you're supposed to be out on the bench just reading all the time. You try to do that in the morning early. That's why you get there early. So it's an interesting life, and it's not for everybody, but I loved it. And again, if you think you're helping people, hopefully you did. That's the object anyway. Where you sit as a 3-judge panel and hear the lawyers argue against the record what we should do, affirm or reverse or whatever, or remand. You go to work in jeans and a sweater because you're in chambers or you're in chambers without, you don't see lawyers except at oral argument. What you have is your staff, your secretary, your 2 law clerks, and you're researching and going over cases and writing opinions and whatever. You do that in your jeans, it's not a problem. But once a week you dress up in the suit and you go to oral argument, put the black dress on and sit out there as a panel and hear the oral argument. We always say, I always started the oral argument and say, counsel, we've read the record totally. I want to concentrate on why you think this case should be affirmed, why this case should be reversed. Give me reasons, point to the record. We're familiar with the record. Okay, go. Let me hear from the appellant first. And we'd ask questions. We'd interrupt them, ask questions. And we hear from the respondent, and then hear some rebuttal. And the oral argument was over. Usually had about maybe like 6 cases for oral argument. 6. Sometimes the lawyers didn't request oral argument. They want you to submit on the paper. They submit on the papers that they filed. But you had 6 oral arguments, and then you start the oral argument around 10 o'clock in the afternoon, in the morning rather, and you finish by sometime 2 or 3 in the afternoon. And then you go home and then you go sit in chambers and okay, you write this one, I'll write this one, you write that one, you write that one. And off we go. It's different in the appellate court.
Interesting.
Go back to putting our jeans on and go the next day.
Did you ever have a case that you guys rather say affirmed or denied, and then it actually got appealed to the Supreme Court?
Sure. Well, sometime before that, you, myself, and another appellate judge, we may disagree. So you and I'll say, you write the case up, let's see how it writes, and then I agree with you, but the other guy or gal disagrees, they can write a dissent. If there's a dissent in the case, there's an automatic appeal to the Supreme Court.
Really?
Yeah.
Oh, wow.
Yeah. But assuming, let's say we all agree, we write an affirmance or reversal, then the attorney that lost can petition the Supreme Court to take the case. I never got reversed by the Supreme Court, but modified one time, I think, a little bit, but not much. You try to do the right thing. And the Supreme Court takes it, they usually take it because they want to change the law, or they think that the law needs to be tweaked a little bit or
Clarified.
explained a little bit more. But I've never had a problem. We've always had a terrific Supreme Court in New Jersey. I started under Chief Justice Wilentz, Robert Wilentz. He was a fantastic, brilliant guy. He called me up on a Sunday morning. I'm reading the New York Times. He said, "Bob, what are you doing?" I said, "I'm reading the New York Times, Chief." He said, "Well, can you come and see me? I have a question about the family court." I said, "Okay, when do you want to do it?" "How about now?" I said, "All right, Chief." I go up to his house in Deal, where he lived, and he was sitting and ask you questions. He didn't want your opinion. He wanted to just get facts. But he was terrific. And Chief Justice Ports, who's the other Chief Justice I served under, she was terrific too. She would say, I want you to explain these child support guidelines to me. Can you come up to my chambers? I would do it. I got charts and I explained. And why are you doing this? Why do you do it? Why is it? You explain it to her. And she, okay, good. Now I understand it. You know, we'd had terrific Supreme Court justices. I've always had a good relationship with them. Even now, I was in chambers with one judge up in, when I was first. See, appellate judges have chambers in different areas with usually 2 or 3 appellate judges are in chambers together, not in the courthouse normally. A couple of the positions have in the courthouse, but I was in Red Bank for a while with a couple other appellate division judges and the Chief Justice, and well, not Chief Justice, a Supreme Court Justice. And then I was with Judge Havey, who was another appellate judge down here in Toms River for a period of time. So we had chambers all over the state, as do these Supreme Court justices. But it's Supreme Court's this is a very, very good Supreme Court. They really do a good job in my view. I have a lot of respect for them.
All right. Well, I mean, I think if you want to give your closing statement.
No, that's it. I think I've said, listen, well, one thing my wife says, I talk too much. But I like to talk about things I like.
Right.
And I've enjoyed our conversation.
Well, thank you.
It's important. I don't think the public knows enough about how the court system works. Not only how the judges get there, but what they do and why they do it, how they do it, and what the rights of people are. And I think sessions like this are good. And more, I think probably the only failing we have is probably there's not enough interaction between the public in general and the court system so that the public understands what we do. There's probably more of that could take place. I don't know how it would be done, but I think that would be important. People, you know, if you don't know what Congress, for example, you know, I don't know that a lot of people understand what goes on in Congress. One of the presidential elections, I forget which one, it's not this one or the prior one, but one in the past, I remember there was a poll where only 15 or 16% of the people were expressing approval for Congress and what they did. And a lot of that has to do, to me, with education of the public as to what Congress does. Same here, education of the public as to what the court system does. I think gives a better understanding, if not respect, but certainly understanding of things so that people understand how the system works. So when they hear things that occur, they can relate that to their understanding of how the system works. Same in Congress. I don't think that people really understand that the congressmen or the congresswoman who are from you know, a certain district in Utah has a responsibility to his or her constituents, and many of the things positions that he or she takes relate to that, and to reflect what her constituents are interested in. And it's a hard thing if you think about it. If every congressman and congresswoman has that kind of situation, you have a conflux of a lot of disagreement and a lot of compromise that are necessary in order to achieve something that would be helpful for the gentleman or gentlewoman from Utah, for example, or from Jersey. And I don't know if a lot of people understand all that. You know, the object is to do the right thing for the country, obviously, ultimately, but there's many shades of that. But I don't know if the public understands that enough. You know, it's easy to say, the court system stinks or Congress stinks. But you have to understand where you put these people in and what they do and how they do it in order to, if you still stink, that's fine, but you know, but at least you understand it
Right.
better. You know, I think it's probably a lack of information and interaction that would do that. I think that would be a good topic for some type of public forum or public entity to do. Nothing but educate the public as to what they do. Not to tell them what to do, but educate them as to what they do. I think that would be an important thing.
I agree. I was actually I was on a campaign more recently as a field director for a local councilman here in Toms River, and like one of the main things that he wanted to kind of promote, he was 23. Biggest thing that he wanted to promote was like a civics education course for like everybody in the public.
I think that's important.
Yeah.
Well, for example, as a trustee here at Ocean County College, I've always advocated we should have a civics course. We don't really have a civics course. I mean, that's for high school. Everybody says, well, I don't know. You know, it wouldn't be a bad thing to have a civics course, quite frankly, so that people understood government a little bit better than they do, rather than, it's easy to say, you know, those people, you know, that kind of thing. It's easy to say that, but if you have a civics understanding of how things work, at least your understanding of it is better as to what happens. Anyway.
But do you think, like, due in part for that is like, I guess like the federal atmosphere in terms of like how they go about, you know, how campaigns are more like sports rather than like actual policy discussion?
Yeah, I mean, look, everybody who runs, I assume they're running because they want to get elected.
Right.
And what they think they have to do to get elected varies from candidate to candidate. There's a lot of negative campaigning we've seen, and not a lot of positive campaigning. You know, it's because they want to win. You know, and the winning game sometimes makes people do things that maybe they wouldn't have otherwise done, and that's a shame in a way. But the public buys into a lot of that stuff too. You know.
Do you think that's at fault of the political campaigner, or do you think that's at fault of the public, or do you think it's a joint responsibility?
Probably joint. But you know, P.T. Barnum said, although if you really research it, it's really not attributable. They can't specifically attribute to the day that he said it, but he's attributed to saying there's a sucker born every minute. You know, and you know, there are certain quote unquote news channels, Fox News, for example, CNN, for example. My view is there should be litigation against them to remove the word news from it, because they're more editorial stations than anything else. They're espousing a view, which is fine, but don't tell me it's news.
Or at least
because
they're biased news.
When you choose your hand-picked panel of experts who have a certain view of an issue, they're essentially brainwashing you in some sense, you know, in some sense, or trying to educate, or trying to influence you to their view. That's editorializing. You know, it's hard to find in news. Like I always say, that where have the Walter Cronkites gone? And nobody really knows who Walter Cronkite was, but he was a fantastic, probably one of the most respected men in the country at one point in time, because he was all about giving you the news. Your job was to think about it and come to your own conclusions. he never told you what to think. Now, many of these stations tell you what to think. They try to push you to think what to think. Walter Cronkite, so we're the Walter Cronkites and Tom Brokaws, and people like that. I had the pleasure of meeting Tom Brokaw, and he is a fine gentleman. They're all about the news. So there's a lot of challenges in society, certainly, but that deviates from what we're really talking about,
Yeah,
which is the judiciary, which we
Which we
just
covered.
hear the case and make the decision, and try to be fair to everybody. It's been a pleasure.
No, thank you. Thank you for your time.